We have another of your favorites today, lawyers behaving badly. And it's an interesting case out of the Western District of Missouri. And it involves a lawyer by the name of Valerie Vance. It's interesting on a number of levels, not the least of which is one that involves a fraud on the court. So let's jump into this. Valerie Vance and Beverly Vance appeal from a judgment entered by the Circuit Court of Jackson County following a bench trial. And again, a bench trial always involves just a judge. And when there is nothing in the case except a legal issue, a judge is appropriate. And in this particular case, that was the case. It was just a legal issue of whether or not a judgment should be set aside. The Circuit Court granted Amanda Everett equitable relief and damages in connection with an earlier judgment which had been fraudulently procured by Valerie Vance. Now, it doesn't say so at this point, but we find out later that Valerie Vance is an attorney. The Vances contend that the court lacked personal jurisdiction, subject matter jurisdiction, and authority to hear the underlying case. All three of those claims are specious, as we'll find out here in a little bit. The court says, we dismiss Beverly Vance's appeal because Everett voluntarily dismissed her claims against Beverly Vance prior to the entry of the Circuit Court's judgment. With respect to Valerie Vance's appeal, the Circuit Court's judgment is affirmed. Now, one of the things that's nice about the Missouri Court of Appeals and almost all the Missouri courts is they don't bury the lead. They always tell you up front what's going to happen, and in this case, that's what's going to happen. So on May 13th, 2016, Amanda Everett and her husband signed a residential lease to rent a 3-bedroom property in Blue Springs for 2 years, ending on May 31, 2018. Landlords will no longer rent you a house for $500 a month. They will rent you a house for $6,000 a year, paid in installments of $500 a month. But they will not rent you a house just for a month. And that's because if you breach the lease, all they get is 1 month's rent. So this way, they can hold you to the contract that you signed, where you breached the contract, and now you have to pay the full $6,000. Now, usually courts will mitigate that. In other words, they will say, well, did you re-rent the property? And if they re-rented the property, then damages will be cut off as of the time they re-rented the property. But that is the way they do things, and this will be important here because it was a 2-year lease. Now let's go on back to the opinion. Based on Valerie's statements, Everett believed that Valerie owned the house and that Everett would pay rent to her. The record reflects the house was actually owned jointly by Beverly and D.V., Beverly's then husband and Valerie's father. Everett was unaware of that, and she paid rent to Valerie through biweekly direct deposits. On July 12, 2017, the Circuit Court of Jasper County awarded D.V. temporary possession of the Blue Springs house. This is another thing that probably drives people crazy when they move in from another state. When you get in through a divorce in Missouri and you have a court that is fairly well backed up with a lot of cases, one of the things that happens early is you apply for an order pendenti lite, which means basically that you're asking for the court to issue some orders to set the ground rules until the case is finally decided. So in this case, the order pendenti lite was used to secure that Blue Springs house for the husband, and it was a lawful order that the court could make. After the court entered this, D.V. sent a letter to the home's residents stating that he had possession and instructing them to no longer make rental payments to Valerie. So Everett called Valerie, and Valerie says, look, ignore the letter. Don't contact that guy. I own the house. I'm an attorney, and I'm going to take care of it. Okay. First of all, Valerie obviously knew that she did not own the house. And more importantly, she knew that her father did own the house, and so she made a material misrepresentation of fact to Everett. And that is part and parcel of fraud and misrepresentation. That's not what actually resulted in the verdict, but we have to talk about the lawyers behaving badly aspect of this too. On November 28th, DV filed an unlawful detainer action in the Circuit Court of Jackson County against Everett, basically. Everett received a summons, and she again called Valerie, and Valerie said, "Don't appear. I'll take care of it. I'm a lawyer." Everett didn't attend the hearing, and the unlawful detainer action was heard on November 28th, 2017. Now, in Missouri, when you file an action, you can file one of two actions. You can file an action for rent and possession, which allows you to get back rent and take immediate possession of the property, or you can file this motion for unlawful detainer. And so here he files an action for unlawful detainer to essentially get these people out of the property. He's not asking for money from them, he's simply asking to get rid of them. She then received a notice to vacate the property in December of that year, which Valerie likewise told her to ignore. Anytime a lawyer tells you to ignore an order from the court, that's not good. That's not wise, and unfortunately, that's exactly what happened here. So, in January 2018, a sheriff came to a victim, and she called DV, Everett called DV, and said, "Okay, you can stay in the house if you'll sign a new lease with me and pay rent to me," which she did on January 19th, 2018. Everett then made rental payments to DV until she vacated the property, which is going to be in March. She believed she was no longer subject to the lease with Beverly and Valerie since DV was the property's legal owner. On February 7th, Beverly filed her own unlawful detainer action against Everett in circuit court. Now you're probably thinking, well, that's kind of strange since, after all, Beverly didn't have actual rights to the property, but she filed this. The petition alleged that Beverly was entitled to possession, claimed damages in the missing rent from January 1, and in addition to interest and other damages. On February 27, 2018, the court held a hearing. Everett appeared without an attorney and consented to entry of judgment against her. I should explain this too. If you go to court without an attorney, there is a good chance that because there are so many deadbeats in the world and so many of these unlawful detainer actions filed, judges tend not to be very sympathetic. And they're quite likely to say something like, "Do you want to go out there in the hallway with this attorney and see if you can work this out?" And of course, in most cases, they don't. And as a result of that, the person consented to a judgment. And a consent judgment is just as binding as any other judgment from a court. Everett appeared, they got the consent judgment. The judge ordered a stay of execution if she would get out of the property within 10 days. So she vacated the property on March 6th, which was within the 10 days. Because it was her belief that at the time that DV continued to own the property, she notified DV that she had vacated and left the keys in the house. Now we get to the sticky part of this case. In the divorce action between Beverly and DV, the court granted possession of the Blue Springs house to Beverly on March 8th, so 2 days after Everett had already left. On March 22nd, Beverly filed a request for a writ of execution for restitution of possession and her unlawful detainer action, claiming that Everett remained in possession. The court issued a writ for possession, an order of eviction, and on April 3rd, a restitution return was filed stating that Everett had been evicted on April 3rd. Everett claims that to obtain the writ, Beverly misrepresented that Everett was still in possession. She believed the matter had been concluded when she moved out on March 6th. So then Valerie begins filing garnishments against the judgment. And she got roughly $500 every month or every pay period and amounting to something like $12,000 between February of 2018 and January of 2021 when she left her employment. On November 13th, Everett began the present action against Valerie in Circuit Court of Jackson County, seeking equitable relief based on her claim that the February 2018 consent judgment and subsequent garnishment orders were procured by fraud. And Everett alleged that she agreed to the consent judgment based on Valerie's misrepresentations that Beverly, rather than DV, was entitled to the rental payments. But as we know, during the entire period of time that she was in possession of that house, only DV was entitled to any rental payments. Everett also alleged that Valerie had pursued garnishment of Everett's wages based on false representations of this failure to vacate. Everett asked the court to set aside the judgment and award her damages and attorney's fees, post-judgment interest, and costs, and to issue an injunction preventing Beverly and Valerie from engaging in further efforts to collect. On April 8, 2021, Valerie made what she labeled a limited entry of appearance, in which she stated that she did not intend to waive any objections to personal and/or subject matter jurisdiction. That same day, Valerie filed counterclaims against Everett on her behalf and on behalf of Beverly. Valerie filed a motion to strike Everett's petition. The circuit court denied the motion to strike. Everett subsequently moved to dismiss Valerie's counterclaims, to disqualify Valerie from representing Beverly, and for appointment of a guardian ad litem to represent Beverly due to Beverly's mental infirmity. The court granted the motion, and the court denied Everett's motion to dismiss the counterclaims. The circuit court conducted a bench trial on January 10th of 2022, and Everett and Beverly's guardian ad litem announced that they had reached a settlement under which each of them dismissed their claims against the other one. And Beverly's guardian ad litem agreed to file a satisfaction of judgment as to the consent judgment in the unlawful detainer case. On the same day, Everett and Beverly's guardian ad litem filed a dismissal with prejudice on their respective claims. The court then heard evidence on the remaining claims between Everett and Valerie. Everett put on evidence to support her claims, but Valerie did not, because now she's asserting a lack of personal jurisdiction. The court vacated the consent judgment and awarded damages in the amount of $35,754. The court also entered judgment in favor of Everett on Valerie's counterclaims. Valerie filed a notice of appeal the same day the judgment was issued. Beverly filed a notice of appeal pro se on August 16th. We consolidated the appeals. Now, it's interesting that she's basing her, at least in large part, her appeal on jurisdictional basis. And that's completely untenable. Generally speaking, when someone gets out of law school, one of the things they understand, usually quite well, is the concept of jurisdiction. It isn't hard. Usually it starts with the Constitution and goes down to any state statutes that in some way modify that personal jurisdiction or subject matter jurisdiction. So let's review real quickly what these are. All right, personal jurisdiction is based on fairness, and it refers to a court's power over a person or entity who is a party or involved in a case, including its power to render judgments affecting that person's rights. But here's the interesting issue. Personal jurisdiction can be waived. It's a personal right, so it can be waived. Now, subject matter jurisdiction is different from that. Subject matter jurisdiction is the requirement that a given court have the power to hear the specific kind of claim that is brought to that court. While litigating parties can waive personal jurisdiction, they cannot waive subject matter jurisdiction. So let's see how the court handles this. At the outset, we note that Beverly lacks standing to appeal. After a plaintiff voluntarily dismisses the action, it's like the suit was never filed, And so, without a great deal of hoopla, they dismiss Beverly's appeal because she didn't have any standing to appeal. She wasn't aggrieved. She consented to a judgment. Then they go after Valerie's claims. In her single point on appeal, Valerie argues that the circuit court erred by failing to dismiss Everett's petition sua sponte, which means on the court's own motion, because the circuit court purportedly lacked personal jurisdiction, lacked subject matter jurisdiction, and lacked authority to consider a collateral attack on the judgment and orders entered in Beverly's separate unlawful detainer action. While Valerie's point is arguably multifarious because it asserts that judgment should be reversed for multiple reasons, they address her arguments on the merits. That's probably something else I should explain. One of the rules of appellate procedure in Missouri is that you have to present a point relied on. You have to say what ruling you are appealing. In this case, the award of damages and things to the Everetts. Then you have to state the legal reason why you are appealing. And in this case, one of those reasons could be they lacked subject matter jurisdiction or they lacked personal jurisdiction. And then you have to explain in this point relied on, which can be no longer than a paragraph, in the context of the facts of the case, why this reason should result in reversal. So essentially, it's a short roadmap for the court. And then you have to list the 3 or 4 cases that you rely on in that point. And those would be the principal cases that you rely on. And of course, the courts do that so that their clerks can pull those cases and they can read those cases if they need to, if they're not familiar with them, so that they are well versed in what goes on in the case and what authority is being asserted. But in this case, in all cases, one of the things that you do is you do 1 point per legal reason. So subject matter jurisdiction would be a point. Personal jurisdiction would be a point. Collateral attack on a judgment would be a point. There'd be 3 points, but here she lumped all of them under 1. Now the court could have, if it wanted to, say, this is a multifarious point. We're not reviewing anything. You didn't preserve anything for appeal. But because it's an attorney, I think it's because she's an attorney, they say, okay, we'll take you up on this. We'll review this for you. And then they proceed to kind of kick her behind in terms that are unusual for a court, in that usually, like I said, when you get out of law school, you know what personal jurisdiction is, you know what subject matter jurisdiction is. But this one's just not right. So, we first noticed her objection to personal jurisdiction. While subject matter jurisdiction can never be waived, personal jurisdiction is an individual right, as I said. In other words, if a party acts so as to recognize that a cause of action is pending and then takes steps that are clearly inconsistent with a lack of personal jurisdiction, the party waives his or her claim of lack of personal jurisdiction. So in one case, they say that filing an answer without raising this is, without a doubt, a consent to personal jurisdiction. In this case, she filed the limited entry of appearance, but then in the same document, she files a counterclaim. So what is a counterclaim? It says, I want this court to decide this issue between me and Everett. But if the court doesn't have personal jurisdiction as to you, and you assert a claim against someone else, your claim would be a nullity. So they look at it from the standpoint of, okay, you want to go after Everett, that's fine. You have now consented to personal jurisdiction. Despite her active participation in the litigation, Valerie did not assert personal jurisdiction was lacking until the day of trial, and that's why she didn't offer evidence. She thought she had a complete win here on personal jurisdiction, which only goes to show you how completely misinformed she was on the issue of personal jurisdiction. Valerie also contends the court lacked subject matter jurisdiction. Now, subject matter jurisdiction, it's part of a long part of civil procedure in law school, but basically, federal courts have limited subject matter jurisdiction. federal claims and cases between citizens of different states. Generally, that concludes the jurisdiction of the federal courts. State courts have jurisdiction over pretty much anything that happens in their state that doesn't raise a federal claim. So it would be very difficult to have an action filed against you in the circuit court where the issue that was being attacked was a judgment that you got in that circuit court for the court not to have subject matter jurisdiction. And so we look at her complaint, and what she raises is claims from a case in 1941. And what they say is, in order to determine whether the circuit court had jurisdiction, we need only ask whether this case falls within Article 5, Section 14 of the Missouri Constitution, which provides the circuit court shall have original jurisdiction over all cases and matters, civil and criminal. This makes the analysis pretty simple. The present case is a civil case, therefore the court has subject matter jurisdiction. And then they claim the court didn't have authority to consider her claims because it was a collateral attack on a judgment. And they say, Valerie's once again incorrect. She relied on Rule 7406, which gives a person 1 year to file a motion to set aside a judgment that was obtained by fraud. It has to be filed within 1 year. But Rule 7406 does not provide the exclusive remedy. Once a time for filing a Rule 7406B motion expires, Rule 7406D leaves open the possibility for an independent cause of action in equity based on extrinsic fraud where the trial court may set aside a final judgment. There's no time limit for that, and even though the petition probably wasn't completely perfect on that score, because Valerie didn't argue that in her brief, she lost on that issue as well. But now we need to consider how much hot water is Valerie in making these ridiculous claims. Well, here are the ethical rules for attorneys. A lawyer shall not knowingly make a false statement of fact or law to a tribunal or fail to correct a false statement of material fact or law previously made to the tribunal by the lawyer. In the original case, she made a false statement of fact that the Everetts were still in possession when she knew that wasn't true, and she failed to correct it. And in addition, in this case, the appellate case, she failed to disclose to the tribunal legal authority in the controlling jurisdiction known to the lawyer to be directly adverse to the position of the client and not disclosed by opposing counsel. And in this case, that's the thing that you can't appeal a consent judgment, and the issue that the whole concept of jurisdictional authority had been wiped out by an opinion from the Supreme Court in 2009. So, it looks to me like she has violated Rule 3.3 or 4-3.3 of the Rules of Professional Conduct, and you also can't use the law to harass, vex, or annoy somebody who is not a lawyer. And you certainly can't give them bad legal advice, which is probably malpractice, I think, at that point, to telling her to, you don't have to show up in court, you don't have to worry about that. That was wrong on multiple levels, and that will probably be addressed too. So it's my hope that Everett will go ahead and file a complaint with the Missouri Office of Disciplinary Counsel, and with any luck, they will take this up and inflict some punishment, some discipline on Valerie, because this is a case that cries out for it. People don't know the law, and a lot of times people who are smart in other ways, nurses, doctors, that kind of thing, they get bad legal advice. They don't know whether they're getting bad legal advice or not. So, to me, I think it's really important for lawyers to behave appropriately and to never put their interests above the client. So when Valerie was asked, what do I have to do here? The first thing she should have said was, I can't give you legal advice. You need to go get another attorney. And the reason she should have said that is because she had a conflict of interest with the Everetts. She couldn't have given them legal advice, and the fact that she did give them legal advice is also a cause for discipline in this case. Now, those are my opinions. The Office of Chief Disciplinary Counsel may decide that I'm wrong, but that's what I think. So that's what I have for you today. It's an interesting case. It's a lawyer abusing her authority, and we can only hope that the courts do something about that, particularly the Missouri Supreme Court. If you have the opportunity today, do something nice for someone. Help them out in some material way and make their life just a little bit better. Thanks for watching. Come catch me down at the beach tomorrow.
If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.